we'll go on the record now then in Sarah versus Sarah. This is Crawford County case 2311355. We're holding this hearing today by Zoom. We have all parties connected by Zoom and including counsel. And we're on the record here today. This is a continuation of a hearing that we began back in May. I did receive some information about at least one of the student loans, which was one of the reasons why we were continuing the hearing. But I guess what I'd like to do before we really jump into things is just get some input from counsel as to what's gone on since the last hearing in May and where we're at and what both of you think we need to do here, at least to get the evidentiary portion of this wrapped up today. So Mr. Vernon, on behalf of plaintiff, I'll have you go first.
So we've been in contact with two different financial aid companies and sent some of those documents to Mr. Cutler and himself in court. We are waiting for documents, and that would have been from Sally Mae that we provided. We are waiting for documents from Ed Financial as they relate to the Parents Plus loan. We had a conversation with them the last several weeks, an ongoing conversation. They have identified that the party's child does have a loan, and that there is a Parents Plus loan. However, they cannot provide that information to me or to Miss Sarah because her name is not on any of the documents. Only Mr. Sarah's name is on the documents. So we've been having to read those documents. They have identified that they need a release from Mr. Sarah to release those documents to us, or Mr. Sarah could get them and provide them. Again, I think some of the discovery that we requested would include those documents. So I think that that's probably something they ought to have provided anyway. But that's what we're waiting on. Based on what we were told, Mrs. Sarah's name is not on any of the documents, which is our primary argument that she's not responsible for those loans. The additional information we have from them, to the extent that it matters to the board or as an offer of proof, is that that Parents Plus loan is transferable to the student upon filing certain paperwork by the parents and the student. So I'm not sure, we haven't seen that paperwork yet. We're still trying to get these things, again, because all these things are Mr. Sarah's names, we can't protect them without his assent. So that's what we've been working on. We would ask this court, that's also why, by the way, we did not file a brief. And the court had asked if we wanted to file a brief 7 days prior to this hearing. We could, we didn't have the information to do that. We're still waiting for that. So we're asking the court to give us another, I would say 14 days. I think if we can get Mr. Sarah to sign the documents, we can get those pretty quickly, and we can provide them to the court, and then brief the issue as to whether a contract signed by one party without the authorization or the knowledge of another is considered marital debt. I think we can brief that issue fairly quickly. And we would ask the court to allow us to do that.
All right, okay, thank you. Mr. Cutler?
Well, Your Honor, it's my understanding that briefs were due. We were set on the same timetable. The court gave a significant amount of time for both parties to present information. I know the court received our brief. I attached the government paperwork, which
we didn't receive a brief.
Spells out specifically what a Parent Plus loan is. It is an obligation of the parents. They receive the money. The student loan is not income. It's not based on need, and it is essentially a marital debt. Both parties wanted to pay for their child's education. Both parties agreed to process this paperwork. The monies came to the parties, and they then spent it for their child's education. Nothing too extreme, nothing nefarious that has occurred. If anything, it was very generous, and it shows the importance of their of education to their family and to their child. So in all due respect, it is a marital debt. It is a marital debt because it is a debt incurred during the marriage. I gave the legal arguments. The court has broad discretion, but in our position, it requires an equitable distribution. It may be that the plaintiff wants her soon-to-be ex-husband to assume all the debts, all the marital obligations. and then she somehow walks away with additional funds. That would not be equitable. That would not be an equitable distribution. We made the argument previously that Mr. Sarah would retain the home, pay the obligations. He will assume the additional marital debt of the tax obligations that we gave a significant amount of information. But the vehicle, which is in wife's possession, would be her obligation. The pension would be divided, and these student plus loans are marital debts. They should remain marital debts for both parties. We would ask the court to indicate that, number one, these student plus loans are marital debts. They were incurred during the marriage for the child's education. I gave some specific government paperwork for the court to look at and rely upon. I think I even gave the web page at the top if the court wanted to look further into the subject, and that they're both responsible for 1/2 of those obligations. It's not a debt that's going to disappear. Maybe something will happen in Congress, maybe not, but as of now, it is an obligation they are required to pay. So in that respect, I would ask that the relief we requested seems reasonable. I believe that we're not being unreasonable. I think we're being equitable in that distribution. The parties have been prolonged in this case. I don't see what an additional couple of weeks are going to do. I don't see that if the paperwork showed, and I don't have the paperwork, but if it showed that my client signed it because he was the only one who had a job at the time, that doesn't mean that it's his debt. It's not his student loan, it's the child's student loan. So it's still a marital debt. So I don't necessarily see the benefit of delay or additional discovery at this point. I know in my mediation summary, I referenced the date. I'm sure the court has it, but we filed, the complaint was filed January 23. So a significant amount of time has already expired. So we'd like to bring this matter to a conclusion sooner than later.
So Mr. Cutler, did you file judge's copies of your brief? Because I did not receive the brief that you're referencing.
I believe so. Let me take a look. I have it true copied by the court. Let me take a look at the proof. I know I sent it opposing counsel. My office is very good about processing this. I'm not in the office right now. You can probably tell I gotta would have to check my staff to make sure. If that was an oversight, I can certainly have that immediately sent out.
Yeah, because I did not receive a copy of that brief, so I have not had a chance to review that prior to the hearing today. The only thing that I received was the loan information that Mr. Vernon submitted. So
we did submit it on May 21st, so I apologize about that, but we're usually very good about having those sent out. Maybe there was an oversight on that, but we submitted it within the time frame court required.
No, I'm sure it was filed, but as you're probably aware, I have a 3-county circuit, and so it needs to be filed in the circuit or in the county that's applicable, but then we also need to have a separate judge's copy sent to my office because I'm not in Crawford County. So that may be where the oversight was. Regardless, I did not receive it. I haven't reviewed it. So I don't know what your brief says, and I haven't had a chance to evaluate the arguments that you've made in that brief. Mr. Vernon, I want to be clear on something because I understand that the government may not release those documents to you or your client because she has not signed on any of those documents. Are you saying that you need some kind of release from?
Yes. They sent us a form as part of our conversation we had with them. They sent us a form that he would have to sign, and I have it here. I moved some things around, so it's right here in my stack of stuff. But we can forward it over to Mr. Cutler for signature so that it can get processed.
All right, Mr. Cutler, do you have any objection?
I don't think I've seen the form, Your Honor. I know counsel asked for my office to issue a subpoena seeking the documents that he requested, and I indicated that I would not be incurring that debt on behalf of my client and that I would not be issuing a subpoena for documents that he wished. I may be wrong, but I don't believe I saw any authorization form.
Well, I would agree. We asked him to do that. And again, I think there's some discovery requests that would cover those documents, but he refused to provide them. But we
don't
can
have them to
send
provide you.
And the release that we received on Friday from the Ed Financial Services. The other problem I have with Mr. Cutler's argument is we don't know what the value of this loan is yet. I mean, the obligation of the parents is unknown. The student can and will at some point take full responsibility for that debt. So the obligation of the parents is unknown. So I don't know how we can divvy that up. My suggestion would be if the court's going to do anything with this without having further information, that it should simply leave that debt as not marital and be subject to the contractual obligations set forth within that agreement. If Ed Financial wants to pursue claims against both parties, then so be it, let them. If they don't, then let them do that. That seems to be the most fair way to pursue this. But to take a debt that we don't know the value of, we don't know what the student will do later with that debt, and then somehow divide that up in a fair and equitable manner seems impossible. So I think the straightforward thing to do is simply say this is not a marital debt and it can be pursued contractually by the creditor in any way they see fit. And we're not doing any harm to anybody at that point.
Well, Your Honor, and I would just respond quickly. This case has been going on beyond a year. Counsel never filed a motion to compel. He never filed a document seeking authorization. I don't know what authorization form he has. I don't know what it provides, but this certainly seems to be untimely by counsel making this request at this point. As the court's well aware, and as the law that I put in my brief, and I apologize, I'll send a copy to your chambers forthwith. The first step the court must decide is whether the debt is marital or not. We cannot merely waive upon the subject and leave it for somebody else to decide. The court has to decide, is this marital or is this not? And the question involves, was the debt incurred during the marriage, which obviously it was? What was the purpose of the debt? It was to pay for the children's education. There's significant case law showing that would be enough to establish it as a marital debt. If the court was to pass along and not make those decisions, obviously I think that'd be inappropriate. I think it'd probably be an error to do that because that's step one of the equation. But secondly, it would then give rise to future litigation. If they came after my gentleman because he has a pension, they didn't go after his ex-wife at that time, then we'd have to bring a third-party action. We'd have to bring more either district court or circuit court actions to have that question ultimately decided. Was this a debt incurred during the marriage or was it not? So to just merely pass and leave some creditor to make that decision is highly inappropriate.
So I mean, hold on.
I'm suggesting that the court rule that it's not marital because of what we've already described. It just took place by one party and not the other without my client's knowledge. What we're suggesting does not in any way interfere with the rights of either any creditor. So, and at least at that point, if further litigation were to occur, then at least at that point, there'd be a known number and a known quantity that could be divided up. Right now, we're in all speculation. I think, again, there's certainly argument here that this is a gift from the dad to the son without further argument or without any further evidence from Mr. Cutler or his client. And that's certainly an argument that's a reasonable one. It does not appear that my client was involved in this decision at all. Certainly from the testimony that there wasn't, and certainly the information you garnered from having conversations with Ed Financial, she wasn't involved at all in the process. So I mean, I think the court construing this as a gift from the father to the son. Okay, again, if the creditor wants to construe it differently and pursue litigation separately, that's on them. But at least at that point, there would be some argument as to how much that debt is, as opposed to the court's speculative distribution of that debt at this point. But again, my initial argument, if you give us more time, we can figure that out.
Well, Your Honor, we already have testimony from the plaintiff stating that she did sign paperwork. She did sign loans. She was aware of the loans, and that was her testimony previously provided to this court. To now claim that she didn't know about it contradicts her prior testimony. And there is no law about gifts. It is a debt. It is an obligation. The law is clear whether it's marital or not marital. And that's for the court to make a determination based upon the information.
Just so we're clear, there were two loans. There's a Sally Mae loan and there's the Ed Finance's parent plus loan. The Sally Mae loan, my client testified that she signed the original document for $16,000. She did not sign any of the additional payments that were made or any releases or loan agreements after that. She did, however, testify she has no idea what the parent's plus loan is, which is consistent with the information that we have received and provided, that we don't have any access to that because her name's not on it.
Her name doesn't, an interesting argument, Your Honor. I know you don't want to really hear argument back and forth. This argument would be similar to the deed. If the deed of the house was only in my client's name, then pursuant to plaintiff counsel's argument, we could claim that's our house entirely and she's not entitled to half the equity. That is not the law of the state. To make that argument contradicts the entirety of the family law jurisdiction. It doesn't matter whose name is on the paperwork. The question is, I'm sorry, counsel, hold on, counsel, please. The question is whether or not it was occurred during the marriage and the purpose, not his name is on it or her name is on it. And therefore they get to carry that loan or the asset. That is not the evaluation at all. The evaluation is, as I said before. So it's not, there's no law about a gift. There's no exemption for it.
You guys aren't making any kind of record. You're talking over each other. And frankly, you're not helping me out at all. So I'm going to have both of you just stop right now because I don't know what's in your brief, Mr. Cutler, again, because I haven't seen it. But we're not any further than we were 2 months ago on this. Because the question that I had for the parties, and nobody's addressed it here verbally, and maybe your brief has the law on this, Mr. Cutler, but what I'm looking for is briefing from the parties on this issue of the Sally Mae loans and the effect of a co-signer, because everybody's talking about, is this marital debt or is this not marital debt, and what's this debt incurred during the marriage? You know, the co-signers are jointly and severally liable. And so that means that I don't know that this is even a debt of the marriage. And I think Mr. Vernon makes a fair point. We don't know if or whether one or either of these parties is ever going to be called on to pay this debt because it's jointly and severally liable. And so what I was looking for after that last hearing, and I went back and watched it, and I felt like I was pretty clear, but maybe I wasn't, was I wanted briefing from the lawyers on what's the legal effect of a parent co-signing on a loan for a child, an adult child, and being jointly and severally liable on that loan. How does that relate to a debt of the marriage, and is that even a debt for the court to even determine whether it's marital or not? And that's specifically, you know, what I asked the parties to do the last time. And then we also have, which is still unresolved, is the issue of the two different types of loans, the Sally Mae loan versus the direct parent plus loan, which the Sally Mae loan, in my understanding, is a co-signing type of situation, and the direct parent plus loan is one where the parents are specifically incurring the debt. In other words, they're not co-signing on it, they're actually borrowing it, which in my view would be more likely to make that a marital debt because they're taking on that debt for their child. So again, we still have two different types of loans that potentially have different legal effects in terms of whether they're debts of the marriage at all, let alone whether they're marital debts or individual debts of one side or the other. So, you know, you guys are going back and forth. You're telling me exactly what you told me at the last hearing. And again, unless Mr. Cutler's brief has law specifically referencing the questions that I've just stated, nobody's done anything in the past 2 months to enlighten me on what the law is. You're both just making arguments that are completely unsupported. And maybe they're supportable, I don't know, but I don't have anything in front of me in terms of authority to support either argument that either of you are making here, again, unless Mr. Cutler's brief has that, and which I haven't received and haven't had a chance to review, and maybe it does. So where I'm at here today is, number one, I want to have a chance to review Mr. Cutler's brief. Mr. Vernon, with the information you have, I want you to have an opportunity to respond to that brief. So I'm going to set this for a hearing on the court's next motion day. I don't know if we'll be able to get that on the docket by next week. If not, then it'll be on the court's next available motion day. But I really think we need to address this issue, the legal effect of co-signing on a Sallie Mae loan, and whether that is debt that's even attributable to the marriage or not. And then the court can move on, because I agree with Mr. Cutler's analysis in terms of the court has to determine, is a debt a marital debt or not, and then apportion that debt. But I don't even know that this is marital debt. I don't even know that it's debt, period. That either party is responsible for in terms of dividing up a marital estate. So that's the way we're going to go forward. And then in terms of the direct parent plus loans, I mean, Mr. Vernon's requesting that information. I want that information. I think the court needs that information. And so, Mr. Cutler, I'm going to direct that your side obtain that information from the federal government. Your client is the one who apparently signed off on those loans, and so you're the one who has access to it. And to me, that's the quickest, most efficient way. Whether Mr. Vernon wants it or needs it or not, I think I need it, and certainly information that I want to be able to see so that I understand what those loans are, how much is currently owed, and based on the contractual information in those loans and the promissory notes, I need to understand how the federal government's viewing those in terms of who's responsible for payment of those loans. And that's, so in my view, that's all information that's pertinent to the court's decision. So I'm going to direct that you obtain those documents. And once those are obtained, copy opposing counsel in the court with those documents. So,
Your Honor, I will certainly, I'm sorry, I will certainly seek that information. If counsel has some emails or addresses where those can be submitted, I would ask them to relay those to my office. We have not issued a subpoena. And the only thing I saw is that one of the responses to counsel's subpoena indicated that they don't have any information. So I wouldn't know where to begin. This is not something my gentleman regularly communicates about, but if he has any addresses or emails, if he could be so kind to relay that to our office.
all right, I think that's fair. Mr. Vernon, you need to cooperate with Mr. Cutler in obtaining these documents.
I understand. We asked him to borrow
Right.
it, and what we're suggesting, or what we identified, was that there were no documents related to Mrs. Sarah. So he said there were no documents to find. That's what we're referencing. Documents are all under Mr. Sarah's name. So.
All right.
I'm sorry, I can't hear, Your Honor. I don't know what he said. He broke up. I'm sorry.
Yeah, I think, Mr. Vernon, that's a conversation that you can have with Mr. Cutler in terms of working out how we're going to get these documents. And then I'm going to set this for a hearing in September. I think we're going to need a little bit of time for this to take place. So the court's going to set this for a hearing on its motion day in September. I'm going to set aside an hour. If we need more time than that, then we can get more time. But I think an hour should be sufficient to address this issue. And that'll give parties time to do whatever briefing they need to do, in addition to what's already been submitted, obtain those documents as to the parent plus loans.
Can I ask for the court's, I'm sorry,
Yep.
email address so I can relay it to my staff?
Yep, my assistant, it's J. O'Rourke at Otsego County.
Is that J as a letter or, I'm sorry, is that J as in the letter J or J as in J-A-Y?
Yeah, sorry, J as in Juliet. J. O'Rourke.
Okay. At
Otsego County, MI. .gov.
Thank you. I'll have that sent to court right away.
Okay, great. Thank you. And then the court will send out notice of the date and time of that next hearing in September, and we'll go from there. One last thing that I want to address with counsel that was also left open after the last hearing was the issue of the personal property. The court directed counsel to communicate and come up with a procedure for dividing that up. Mr. Vernon, on behalf of plaintiff first, is that something that's been able to be accomplished?
We had no conversations with Mr. Cutler's office regarding the division of personal property.
All right, Mr. Cutler.
I believe my client, and I'm not in the office, but I believe he created a number of pages for property. I thought those were sent to opposing counsel. I will double check, but I will see where we stand on that because I realize that wife has not been in the home for some time. So I asked my gentleman to go room by room and just identify in general fashion whatever might be in any given room and indicate whether or not there was something that owned by either party before the marriage or acquired during the marriage. So I will double check and see where we stand with that. I thought it already went out, but again, I don't have that in front of me.
Okay, so by that next hearing in September, I'm going to ask the parties to either have reached an agreement as to items of personal property. If there isn't an agreement as to those items on that date, then the court will refer it to mediation on the personal property issue only.
Thank you.
Okay. All right, thank you. That's all I have for today. All parties are free to disconnect at this time.